Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because they agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. You guys know who I am. I'm Pam Esquire, also known as your law intellect. And I just so happened to check the docket on the TD Jakes versus Duane Youngblood. And if you guys recall the other day, I did do a video of which Tyrone Blackburn was begging for the court not to sanction him money. TD Jakes has responded. And I don't know what to say. I don't even know what to say to Tyrone Blackburn like right now. What is going on with you, bro? Sister counsel to brother counsel, what the heck is going on with you? What is going on with you? You about to see what I'm talking about in a second. Hey, Dorothy Carter, how are you? Hey, Auntie Gigi, good to see you. AK, Grandma 504, Beverly Pierce. I had to jump on here. At first, I was like, oh, I'll just throw this documents in the membership. But because I already pretty much went over, obviously, the motion response from Blackburn, I figured, let me complete it. And if there's a reply. So what Jake's team is doing is they're requesting permission in order to file a reply, but they let the court know what the reply was going to be if they got permission. And basically, if the court says it's fine, then what they will more now it can be considered when the court makes its decision. But I can't believe let's get into this. Okay, we got to get into this, y'all. Hey, gotta love Jones. Good to see you, Miss D. Good to see you. Straight like that, Miss HLS. If you guys could please do me a favor and make sure you hit the like button so that other people know that we are on. That would be so great. And subscribe to the channel if you have not done so already. But for those that have been following the TD Jakes saga, there is a lawsuit that TD Jakes filed against Duane Youngblood for defamation. And I think it's civil conspiracy. The case hasn't even really gotten to the nitty gritty, even though it's been filed for months. They've been going back and forth. I think he filed it last December. And they've been going back and forth with motions here, motions there, motions everywhere. Well, Blackburn was the attorney that was representing Duane Youngblood. Notice I said was, because Duane Youngblood basically fired him and decided to go with the local counsel that was already on the file. Well, it's just been a roller coaster ever since. So before Blackburn left the case, he allegedly filed a brief that had a bunch of citations that were misquotes and hallucinations and all of that. He blamed it on AI. Court made him show cause. He went into for a hearing, and I guess he just, threw himself at the mercy of the court, stood up as, said, yeah, I did it. I'm sorry, but it's because of the AI and they had new features and da 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 da. So then Blackburn, the court said, well, I'll hold it under advisement. However, if Jake's attorney would like to file a motion for attorney fees, then you go ahead and do that. So, of course, Jake's attorney filed a motion for attorney fees, and Blackburn responded to it. And in their motion for attorney fees, they asked for about $76,000. And so Blackburn responded that we went over the other day. He was like, I ain't got it. I'm broke. I have 60. It would just basically it would deplete my whole firm out. I have 60% pro bono cases. I'm trying to help the world and the community. And so please, judge, just let me do continuing legal education as other cases, other cases I've looked up has allowed. Well, Jake's attorney, and then I guess there was also an allegation of, y'all, we read it, so you can go to the video when we get finished. There was also an allegation that I guess Blackburn was going around saying that he was sworn in, or he was licensed to practice in DC. Well, Jakes has attached a document that shows that they said you are not licensed in DC. And as attorneys, when you know people are going around parading talking about their license somewhere, you're supposed to, you have a professional obligation to report them. So don't be saying my reporting is frivolous. I'm letting the bar know you out here wilding. So they attached the document. Then they had another document, an email from Blackburn. You had to know this email was going to end up on the docket, and you just really just say whatever, like you just don't even consider or think about it, or type the email and then be like, cuss them out in the email and then delete it like we all do. And then you say, respectfully, da 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 da. You go over it a few times so it sound good. You literally sent let me show y'all what's going on here. I'm flabbergasted. I'm so flabbergasted that I'm just like, this is just crazy. So Jakes has filed a motion for leave to reply to Blackburn's fee opposition. Plaintiff Bishop Thomas Dexter Jakes requests leave to file a reply to Tyrone Blackburn's untimely opposition to plaintiff's motion for fees. So basically, you ain't even do it on time. Okay, your opposition was late, is what they're saying. To set the record straight and to refute unwarranted aspersions cast on plaintiff's counsel again. If granted leave, plaintiff will make the points that follow. First, the New Jersey bar referral, which Blackburn complains about, was not submitted in bad faith. Contrary to his representation, Blackburn is not a member of the DC bar, which the organization has now confirmed repeatedly, once in writing. And the DC Bar Ethics Council advised plaintiffs' counsel that we had a duty to report the false bar membership claim to the relevant state bar under Rule 8.3a, which Blackburn knows because it was explained in the New Jersey bar referral, which he filed with this court. So let's pull this letter up right quick, right fast. I'm just so, I don't know. Sin, thank you so much for the super chat. I appreciate it, Shig. Sharon T. Leonard, thank you so much. You said hello, Musk got his degrees from dump. I don't know, but I'm getting mad. I'm getting mad as hell now. Like, who goes to school and spend all that money and just out here just come on now, bro. I have faith in you, bro. You see, I was refraining from I have faith in you. Okay, let's pull up the DC bar decision. Exhibit 1. Dear Mr. Posh, we review the disciplinary complaint that you filed against Tyrone A. Blackburn, Esquire. Because Mr. Blackburn does not hold a DC law license, We have no jurisdiction over him. I assume from the footnote in your letter that you have reported this conduct to New York and the federal court in Pennsylvania. If you have not, please do so. You may also wish to report the conduct to the DC Court of Appeals Committee on unauthorized practice of law. My God, today. Bro, what are we doing here? I don't even understand where this conversation about practicing in DC even came from. I don't know. Oh, did I miss something? I'm like, what does it matter? Like, they're in Pennsylvania right now. I don't even know where it came from. So there's their proof that they said that he did not have a license to practice there. Let's go on. Thus, contrary to Blackburn's claims, the New Jersey bar referral was not submitted for an improper purpose, but in good faith and to fulfill counsel's own ethical obligations. Second, Blackburn's recent conduct belies his claims of contrition and good character. When plaintiff requested consent to file this motion for leave, Blackburn responded by calling this case a waste of his time and threatening Bishop Jake's daughter. What are we doing? What are we doing here? And this is the email, y'all. What are we doing here? So this is the email. So he asked it, of course, Jake's under the rules. Before you file motions, you ask the other side for consent, for concurrence. Because if we can agree to what I'm about to file, then it's no sense of me filing. So, of course, when you're asking to reply for against him on the fee situation, on how much attorney fee was, he was probably going to say no, but you still have to usually put in there, I attempted to meet and confer, requested concurrence, and they denied it. So you put that in there because the court feel like we grown ups. So if there are issues that you don't have to involve the court, please resolve those issues. That's usually it's things like discovery issues we usually can stipulate to, like, okay, I'll have your discovery in 10 days. I have my client fill out paperwork. But when they're trying to dismiss your case, obviously, usually like, no, I wouldn't have filed it if I was going to concur. But you do have to request, consent. So they were trying to get Blackburn to just stipulate and consent for the reply motion is what it sounds like. So they sent him a letter that said, let me blow this up because it is little. Dear Mr. Blackburn, we plan to file a motion for leave to file a reply in response to your late in time response to our August 1st, 2025 fee petition. Your response raises new issues unrelated to the fee petition, such as your new claim that you are in fact a member of the DC Bar and were sworn in by Magistrate Judge Catherine Parker on May 7, 2024. Please let me know by 12 p.m. tomorrow whether you consent to or oppose our motion. I am also providing you with a letter I received from the DC Bar on July 11, 2025, notifying me in writing that you are not a member of the DC Bar, despite your representation to this court and to Judge Parker, and of my obligation to notify other jurisdictions of the issue. See attached. So Blackburn responds. So this was on yesterday, 5:48. Blackburn responds, no, I do not consent. I am no longer wasting my time with you or this case. You filed a bar complaint in bad faith, and the court will see that. As an aside, please ask your client, Mr. Jakes, if he and his daughter, Cora Jakes, will be willing to waive service of process for the upcoming lawsuit I will file on behalf of Richard Brandon Coleman. So for those of you that do not know, Cora Jakes, the daughter of T.D. Jakes, was married to Richard Brandon Coleman, and apparently and allegedly, one of the kids that they adopted, because they adopted two kids. One of them is Michelle Lyle's son, the one that's saying that Cora, there was some I don't even know how to explain it. There was some issues with that adoption, is what Miss Loud is alleging. But there was a little girl as well. There was a daughter, so it's a son and a daughter that they adopted. So Cora, I guess the daughter alleged that Cora's husband was sexually abusing her. Brandon Coleman went to print. Well, he ended up getting arrested, was in jail, and while he was waiting, from my understanding, they offered him a plea, and it was not as many years, and he turned the plea down. Well, suddenly, to most of us out here, he ended up taking a plea. So some people have looked at a little shaky on the whole plea situation, on how he just took a plea, but he took the plea and he pled guilty. And so now he is doing a whole lot of time for allegedly touching their daughter, whom they adopted. So apparently and allegedly, what I get from this is Blackburn then reached out to this man over there in prison and is going to file a lawsuit against TD Jakes and his daughter based on this situation. Yeah, she was the one going live and going on a different channel saying that her son got taken from her. That's who Michelle Loud is. Yeah. So that is the whole brief breakdown of the Cora Jakes Brandon situation. So they have Coleman is plaintiff's daughter's abusive ex-husband, who is currently serving 20 years in Texas State Prison for child X crimes with the projected release date of 2042. And so then they have the inmate information. If y'all want to look them up, they got the footnote. Third, despite this court's repeated admonitions about grievous citation errors across multiple filings, Blackburn has again misrepresented cited cases. Didn't I say in that last live that I did, I was like, I know you better have double checked all these citations, because you know they waiting on you to miss a quote. They are waiting on you to spell a word backwards or whatever it is. So make sure all your citations are on point. They are alleging you still misrepresented cited cases. For one, they said Blackburn states that the court in Johnson v. Dunn, quote, only ordered, quote, corrective education. That is false. The court also disqualified the attorneys and referred their misconduct to the, quote, applicable licensing authorities, end quote. Then they put the case number. But most egregiously, despite claiming to now understand the import of quotation marks, and they have a footnote that says, see Blackburn sanction opposition at 8, where it says, quote, I now understand that paraphrases, particularly those closely tracking the language from cases, must never be enclosed in quotation marks unless they accurately reflect the precise language of the cited source, end quote. Blackburn again quoted language from a case that does not appear in the decision. The N. Ray Hill case over there in the Western District of Pennsylvania, the court never used the words, quote, lied to the court, end quote, and, quote, showed no remorse, end quote, as Blackburn represents. Rather, quote, lied to the court appears only in the head notes, and, quote, showed no remorse appears nowhere in the document. They are catching every mistake. While the case may reflect these sentiments, this example refutes Blackburn's claims to, quote, now understand that paraphrases, particularly those closely tracking the language from cases, must never be enclosed in quotation marks. They trying to get you. Oh my goodness. Okay. Fourth, and at the risk of beating a dead horse, plaintiff again notes that Blackburn's claims to have, quote, acknowledged his error immediately and demonstrated remorse and corrective action is false. As the court knows, his reply doubled down on the misconduct and falsely accused plaintiff's counsel of engaging in misconduct too. He took the same approach here, falsely accusing counsel of submitting a bad faith bar grievance, knowing that they were advised of their duty to report the situation. Finally, Blackburn filed his opposition nearly 2 weeks late without requesting leave. In conclusion, accordingly, plaintiff respectfully requests that this court grant leave to file a reply containing the foregoing material or alternatively consider this filing as the reply. And that's from Mr. Dustin Potch over there in Washington, D.C. Blackburn, what is going on, bro? Yep, legally bound. That's exactly what they're doing, combing over and I, because the quotation part to say, well, that's from the head. No, that's not in there. And really, like I said, all he has to do is say, if he's paraphrasing, don't put quotes. And then you can say, see this case generally where it cites blah, 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 or it's holding in parens. It's not that deep. So I don't know if Blackburn is trying to make it look better by putting quotation marks around some of this stuff allegedly. I'm not double checking to see if he did or not. I'm just saying these are the allegations from Jakes. I'm sure he probably has a response to that. But that DC letter said that he was not barred there. That's what that letter said. And then the fact that you're going to represent Brandon is interesting to me. I said that, Simi. I said that. And he went on a platform and was like, yeah, I watched Pam Esquire too. And Pam, I am going to get me a paralegal. Because I was like, you need a paralegal. You can't be doing everything. There are times when you may have a handful of cases. So no, probably wouldn't make sense. But if you're taking on these big cases against celebrities that you know they're going to hire big firms, then you need to get you a paralegal. Because they are going to paperwork you. They are going to look line by line. I look at every case when people file stuff. I look to make sure it says what it says. I actually responded to a brief today where they misquoted a statute. And I was like, I think they meant to say this, but they said that. No, they didn't attach this and they didn't attach. They said exhibit B says A, B, C, D, and E. Nope, exhibit B don't say none of that. So I know I've been doing that since I started practicing to make sure that whatever they quote stands for the proposition of what they say that it is. When you have a big, huge firm and he has a couple of firms working for him, you think they not going to comb through there and find and look at every citation and make sure it says what you say that it said? Then the DC, you didn't even have to put that in the response. Like, why did you even put that in there? I think he wanted to give the impression to the court that maybe the other side is just at this point almost trying to ruin him. Because he said that a few times. So maybe he feels like if he, and I'm speculating, but maybe he feels like if he puts in there, they trying to call the bar. Well, they're not the first attorneys that said they're going to call the bar on you. They keep quoting the people over there in federal court in the Southern District, the judge that said she was referring you to the bar over there. So it's been a few attorneys on these cases that have said it. So they're not the first one. So I think maybe that is the look he's trying to give. And then they just came back with paperwork to show that if you are barred in DC, then somebody missed the memo. Somebody missed it. Okay. But Tyrone, I was rooting for you, bro. I really was rooting for you. But now you just, it sounds like you are just they don't attach receipts. I'm just saying they attach evidence next to their in their pleading, and I tend to believe personally, in my opinion, what they said. Okay. I don't even know what to tell you. If you want to be done with this case, I'm at a loss for words. I'm at a loss for words. I'm not even gonna hold y'all up. If anybody else has words, that's not too bad. No, I don't know if I should let y'all come up here or not. I was gonna have y'all come up here. Yeah, y'all might have a roast session on Blackburn. I'm not trying to do all that. He already over there fighting for his bar license right now. Seton Hall is supposed to be a pretty good law school. That's where he went. Legally Bound said an experienced paralegal will save your practice. Judges are coming down on poorly written docs. So that is 110% correct. One of the things, and a lot of people know my story, but at first, that's what I wanted to do, was be a paralegal. I did not want to go through the process of being a lawyer. I love the law with all my heart. But by that time, I was grown, and I had kids, and I did not want to go through the process. So I went to school to be a paralegal, and I met a lot of people while I was there. And one of the ladies that's a paralegal, I'm really close to two of them. One of them worked for me when I became a lawyer, and she was like, a paralegal can make or break your practice. A paralegal or a secretary, they interchange them. But they said, and I'm like, well, she said, oh, it's been times that new lawyers come out and they think just because they have a license, they're better than you. And they're just not learned. They don't know the rules like that. And you can lose by procedure. You can lose by, again, misquoting and misciting cases. Your paralegal can cover all of that. So always be nice to your paralegal. And she always said that, like, attorneys should always be nice to their paralegal. So I never finished that program. I was about a class away from getting my little certification, and I decided to take the LSAT and go ahead to law school just randomly. Somebody probably made me mad, and I think that's what happened. And I was like, let me hurry up and fill this out. I'm about to go to law school. And then I like took the LSAT in like December or November or something. And then I applied for a few schools, and one of them was like, you can start next semester on the weekend. I was like, sold, and I just started just like that. But yeah, I've seen some people that I know that are my friends, when those attorneys get out thinking that because they have a license, they're so much smarter, and these individuals, male or female, have been doing this paralegal work for decades, and you think you know more than them because you just passed the bar, the law school does not teach you how to practice. They don't teach you how to practice. So when you get out, I seen where they were like, yeah, this new lawyer, she had all the rules wrong. And I kept telling her what it was, and she ignored me. So I was like, okay, well, I'm just going to go ahead and file it how you said. Now she got to go and stand before the judge on an order to show cause. And she just laughed. Like, so yeah, paralegals a good paralegal. Now you can get some, I've had some whack ones too. You can get some whack ones too where they don't really want to do any work. But for the most part, I've been really lucky with the people, were blessed with the paralegals that I've had. But very important, Tyrone, I told you, if you get through this, Tyrone, I told you, get you a paralegal, because first of all, I don't like the way you write. I don't like the way it irks my everything, the formatting, not spacing it correctly. I don't like it. And I know that's just a pet peeve of mine. That's not what's important. The substance is important. But I'm just saying, if you got you a paralegal, it will help you a whole lot. And I get it. You're saying you pro bono. You get some that's freelance. They may just do it where you can hire them on a specific case and you just pay them part-time for the cases that they do. I know you can do that. Just saying, I know you can do this. Hey, for always, forever. Yeah, I'm back for a few minutes. This is an thank you, Heather. But that's it. I don't know what to say. I don't know. You know what Natasha said, his paralegal. Sonia. Listen. Blackburn, we have someone for you. Her name is Sonia. And she probably would love to be your paralegal. Actually, that might be a good match. So go get Sonia. Her name is Sonia Cochran. Okay. She can be your paralegal. I could put in a good word for you. I see her every now and then at court. And she she is traveling around right now in her RV. And I'm sure she's available. I think this might work for her. Thank you guys so much for the suggestion. I think this actually might be a good fit. Oh my God, today. All right, y'all. I just had to come on and share that. Because sometimes I don't know, Black. What is going on with you? I'm trying to wrap my head around what is happening right now. I'm trying to really wrap my head around this. I just don't know. I don't know. Yeah, she's riding around in the RV across the world right now. That's what Sonya is doing. You have to go watch the Ernest Williams stuff with Shirley Strawberry to know what I'm talking about. He should have listened once you lose your credibility. Well, the problem is he seems, in my opinion, by looking at that email, there was nothing professional about that email. He seems a bit hot-headed, in my opinion, Mr. Blackburn. Like, you go off, a lot of us feel some type of way. It's a lot of lawyers. I'm not going to say a lot. I'm going to say it's about 3 lawyers that I dealt with that I cannot stand. Literally cannot stand. So, like, whenever we go and we face off, and because of the area law that I do, they represent insurance companies all the time. So I'm going to run across them. And we go back and forth and we file motions against each other and we go off and we do all of that. But I still am professional. Like, I go off verbally, but I'm not going off in no email. In the email is brother counsel. Pursuant to our most recent conversation, I just wanted to confirm and reiterate that you said you are not turning over A, B, C, D, and E. Respectfully, I believe that it is relevant to this case, and therefore you leave me no choice but to file a motion to compel that discovery. So I'm requesting your concurrence. You have until the end of the day before I respond. Please let me know what you choose to do. I hope you're having a great day. Because you know what they're going to do? Whatever your email is going to be a part of that docket. You get what I'm saying? It's very rare that I see emails where people are really saying how they feel for the court to see. But you're sitting up there and you're responding like, oh, and by the way, let your client know and his daughter that I'm suing them. Like, where are we, Tim? Are we really just like, we gonna threaten people with a lawsuit because you mad? Because $76,000 that they're requesting, I do think it's pretty darn high. But still, come on, you added extra stuff. We didn't have to know about DC. The email, they just requested concurrence. All you had to do was say no. If DC came back and said something different, you could have came with your proof if you're alleging that, or just say, my bad, maybe something went wrong. But to respond by threatening another lawsuit when you can't afford this one is like diabolical to me. You have told the court, I can't afford this case. I can't afford the sanctions on this case because I am 60% pro bono. But yet I am going to file a whole new lawsuit against Bishop Thomas Dexter Jakes of the Potter's House, Oprah's friend, and his daughter. And you think that's about to be cheap? That's not going to be cheap. I don't get it, Mr. Blackburn, but I Godspeed. I don't know what to say. I was really feeling bad because when people, I know how hard it is and how hard you work to get licensed. And the fact that you are licensed, and I think it's, well, apparently ain't DC, but New York, New Jersey. And again, they came with a letter saying it wasn't DC, but I guess maybe you got something that says different. It was maybe something got lost in communication or in the mail. I don't know. But what I do know, it ain't looking too good. I was out here rooting for you. Everybody in the chat the other day was like, sanction them, give them sanction. Give them sanctions, judge. If I was the one making the decision, he'll be sanctioned. I'm like, no, don't give him the sanction. That's not nice. And now you left me. I can't even say anything. I have no defense for you. I have no defense for you. I don't know. Make sure y'all hit this like button. No, Straight Like That said he is literally digging a hole deeper and deeper. That's what it's looking like. Why don't you just respond and say, I can't afford it. I did the best I can do. Here go my CLEs. I was wrong, judge. If you could just please, baby, please give me one more chance. And that's it. But all that extra I'm going to throw in there about he's trying extrajudicial conversations or whatever he named it, of which there was some type of lie about whether he was a part of the bar. Like, all of that was so unnecessary. What was the court going to do about that? That's why I said the only halfway logical reason that I can come up with is that I think he wants the court to believe that he is somehow being targeted or bullied in some way. And so the court can see that they're just messing with him. Like he said in there about them trying to ruin him. And I think that he said he has to get an attorney now because of this allegation. But as they said in a footnote, let me pull it up. In one of the footnotes, they said, and if Blackburn were a member of the DC bar, he would not need ethics counsel to defend himself. It would simply be a matter of providing a certificate of good standing or even a dues receipt and explaining there have been some kind of misunderstanding. That's all I'm saying too, Blackburn. I don't understand. If you can show either one of those, then why would you need? You just submitted to the bar. Why would you need an ethics attorney? And then you want to blame them for what things that you've done, allegedly. I don't know. You did for always forever. You did. You said you did. You said he was trash. And you said I'm not mean, I just tell the truth. I have a very hard time when it comes to I personally had interactions with lawyers that weren't the best, yes. But I've never ran into a Blackburn. I've ran into some lazy lawyers. I've ran into some misogynistic lawyers. I ran into some prejudiced lawyers where you can tell by the conversation. You know, I've ran into various types, but I have never ran into any like Blackburn ever. Like that, just the emails like that. I've never had that. I've never dealt with like just a whole like I said, I've caught some mistakes in some briefs, but I've never had to go through 50 citations and then the majority of them are wrong. I've never had that situation. I've never had us going back and forth with each other in pleadings. Blackburn in another case, I believe the judge said something about I don't think it was this one. I think it was one of them Diddy cases where the judge like mentioned some of the digs that happen in the pleadings. You got to learn how to be professionally shady in these briefs. You can't just straight up be like, you was a clown. You know, you can't just straight up, you's a clown. You suck at what you do. No, you can't do the Whitehead. You can't.
You's a clown. That's what you. Why don't you call me a cardboard bishop now? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh? Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
Maybe it's that New York energy. You know, that New York, just everything is animated and loud and all of that, like Whitehead. Maybe that's what's happening. I don't know. I've never ever dealt with anybody like that. But you know, I hope he gets it together. He gets him a great mentor who can help him along the way. That's all I can say for him. That's all I can say about Blackburn at this point. You know, I looked up Whitehead today, ironically. And you know, he of course he appealed his case, but he was also trying to get out on bond, I guess, pending appeal. He tried to get a reconsideration. It was just a little confusing. He was trying to get a reconsideration, I think, on his motion for a new trial, and I think it was denied. And then he filed a habeas, and I think that was denied. But he is requesting oral arguments. So he just requested oral arguments the other day for his appeal. Should I go to that? If they grant him oral arguments, should I go to that? I don't even know if they're going to grant him oral arguments, but here's the document for that. I literally just pulled that up today. Hold on. I'm sure Whitehead misses me. So this was the document that was filed June 20th, 2025. So yesterday. So appellant proceeding pro se. So he was, you know, he represent himself. Moves for informa pro petis status reversal, reconsideration, and permission to file an oversized reply and other supplemental filings. Upon due consideration, it is hereby ordered that the motions to file an oversized reply and supplemental filings are granted. So he gets to file supplemental, and you know, there's a certain amount of pages that you can submit. And so the court is allowing him to file more pages. That's all that is. It is further ordered that the appellant's remaining motions are denied and the appeals are dismissed because they lack, quote, an arguable basis either in law or in fact. To the extent appellant seeks reconsideration of this court's previous order denying his motion for bail pending appeal, filed in his appeal from the judgment of conviction, that request should be directed to the panel that determined that motion. So the panel that determined his motion denying him bail pending appeal, he needs to go over there to that panel and ask them to reconsider their opinion denying him that bail. So he was trying to get out pending his appeal. So what he's essentially saying is that he believes, because they'll let you out on bond pending appeal if you have a chance of winning. And so it was denied. And now I guess he wants to try to seek reconsideration of that opinion. But he did request, I was looking it up, where I think it was last week he requested oral arguments, but I didn't see a date of when he'll have oral arguments of his appeal. So when I get a date, you guys will be the first ones that I tell. I'm not trying to piss him off. I'm supporting. I'm supporting. You said sucker. I wonder, you know what? I wonder how. So what'll happen is he probably wouldn't be there anyway. It would just be his lawyer because he's locked up. So they don't have to, from what I understand. Well, I'm just gonna speak for Michigan. In Michigan, I know the appeals where people are in prison, they don't Zoom them in or anything. I'm sure there's exceptions to the rule, but I don't know generally if that's something that they do over there in federal court of appeals. Your lawyers just go there and argue your case. So I don't know if he would be there anyway. Yeah. So anyway, y'all, I'm about to get off of here because I'm about to go eat. And I hope you guys enjoyed the live. And Tyrone, I was rooting for you. I don't understand what's happening here. Do you need to talk to somebody? You know, they always send us information for therapy because, you know, we got one of the highest drug and alcohol abuse out of professions because y'all people out in the public be stressing us out. Immediately when I got my bar card, they were sending me lists of AA for women, AA for single mothers, AA if you're LGBTQ, AA for if you're this, NA if you're this, NA if you're married, AA, like they immediately figure you about to be sipping on a little something in this profession. So I just got a survey where they were trying to, like, I guess, gauge the mental health of a lot of the lawyers or whatnot. So they were doing like random assessments. So I'm saying I think your bar help you if you need it. If you got some issues going on, if you stressed out, maybe you just need to talk to somebody. I don't know what it is. I don't understand playing with licenses. I'm not playing with my bar license. I'm not gonna do it. You see, when people have called me about cases in Michigan and I may not have taken them, I still don't talk about them on my platform. Won't be me. It is very stressful. It can be, especially if you care. If you've learned how to like not care, then it's not as bad. But when you really care about your clients, if you do personal injury, you have clients that were obviously injured, medical malpractice, wrongful deaths. Those are people that have died in the court. They have families out here. You have some injuries where they're paralyzed, lose limbs. I've had some very tear-jerking cases from the civil side. Then, of course, you guys know on the criminal side, I fight for people that are innocent and were wrongfully convicted. So that's a whole nother level. So you have to learn how to kind of balance it, because I think you fight harder when you care like that. So I'm not saying take away your empathy, but you do have to learn how to compartmentalize it, and you have to learn how to turn it off. That used to be my issue why I couldn't continue to do criminal defense, because first of all, I wasn't on a court appointed list. So I pretty much believe just about everybody that I represented didn't do nothing. I still feel that. So if you get something unfavorable, even if it's just a lesser offense, or you want your client to walk away, or what, it's a stressful situation, because I always said, even on the civil aspect, if you lose, okay, financially, you might not be able to buy something you've been saving up for some years. But when it comes to criminal, if you lose, that's literally somebody's life behind bars. So it can be very stressful, especially if you are a caring attorney, of which I hold myself out to be. So WJs, thank you so much for replaying the live. But anyway, y'all, I'm out of here. So y'all, I'm gonna holler at you later. You guys have a good night. I don't think I'm coming back, but you know, who knows? Let me go eat my food. I'll talk to you guys later.